I'm speaking to you from Cantor Injury Law today about slip and fall cases. And there is snow and ice, so I say drive slow and nice, and it applies to walking as well. Simply because there's ice and snow on the ground does not give liability to the landowner if you slip and fall. A lot of people call me up and they say, Mark, I fell, can I sue? And the answer to the vague question about can I sue is always yes, but I won't handle the case unless you can sue and win, because I'm only interested in meritorious claims. So if you fall on someone's property on snow and ice and you're injured, does that mean you win? And the answer is no. Simply falling someplace does not give you the win. You must show that the landowner knew or should have known of the dangerous condition to property, and that you were unaware of that condition. Snow and ice is a known condition. If you fall on snow and ice in Missouri, tough. If the landowner didn't take efforts to clean that snow and ice and you simply fall, you lose the case. Now, if they do shovel and they salt part of it and don't salt the other part, and you step on black ice, which is snow that's melted and then refrozen and it's clear and you can't see, then I think I can win your case. So the facts are important. People come to me and say, hey, I slipped and I fell. Am I going to win that case? And I say, well, what did you slip and fall on? And they say, I don't know, but it happened at their property. I say, so what? You know, just because you fell doesn't mean you win. You got to know exactly why you fell. If you don't know, how is a jury going to know? So if you have a slip and fall, call me up. We never charge a fee unless we win, and I've handled these cases for 30 years. Our phone number is 314-628-9999. If you want to continue to watch, I'm going to give you a couple examples of cases that we won. I once sued an oil company in Morgan County, Missouri, a gas station. A woman went into the bathroom. She walked right past a caution wet floor sign, and the whole defense to that case was, hey, look at this sign. She walked by a caution wet floor sign, but the floors were dry. My client went into the restroom. She was there for about 2.5 minutes, and she came out and she slipped and fell. We won that case because I was able to prove to the jury that the oil company had a woman that worked there until noon. And at 11:54, my client walked in. She used that bathroom for just a few minutes. And during that time, a person mopped the entirety of the oil company's floor with one greasy mop. So my client walked in on dry floors, used the restroom, came out, and slipped and fell. We got a $600,000 verdict on a no-offer case. And the reason we won that case is because the jury understood that a caution wet floor sign on dry floors means nothing. So you don't win just because you were there and you fell, but you could win depending on the facts, and that's the largest verdict in Morgan County. So I'm happy that we won that. I also won a case for client Joan Alter that was well publicized. She slipped and fell at the Science Center, and the offer was $500. I won her $966,000 by settlement. That's because the landowner had a dangerous or hidden condition. It was a fencing company. They had left a pole on the sidewalk, and when my client turned the corner, she didn't see it. She slipped and she fell. She tripped on that pole and she broke her shoulder. So we won that case because there was a dangerous hidden condition of property which the landowner knew or should have known of, but my client didn't. So I've seen the gamut of these injury cases, from slips, trips, falls, ice, and snow. And I can help you win. I can help do the analysis. We never charge a fee at all unless we win. Thanks, and thanks for watching.